And Your Honor, as to Ms. Santiago, she is present 2020 CF 2970. She is here on a VOP on 1 count, possession of a controlled substance. She is prepared to admit to that VOP today. She will be adjudicated guilty. She previously was. We're going to modify her supervision to serve the next year on community control, and then that will be followed by whatever remainder of her original term of supervision on standard probation. She will need to submit to a mental health evaluation within 30 days and begin any recommended treatment within 60. She will also still need to submit to a substance abuse eval within 30 days and begin any recommended treatment within 60 days. There is a $100 VOP cost of prosecution and a $150 cost of defense that she'll need to pay. This is kind of an unusual situation, but Ms. Santiago has been asked if she would be willing to complete the Bridgeway residential program for her misdemeanor case, and she is willing and wants to do that. So I've just included on the plea agreement that probation would not need to seek leave of court. They could substitute the Bridgeway residential program for that substance abuse and mental health eval and treatment without further order of the court. So we just ask that the court authorize that for probation. For probation's information, Ms. Santiago has a hold from Jackson County and also a misdemeanor case that will need to be resolved before she's able to go to Jackson County, so she won't be released today. May I approach?
Yes, ma'am. Thank you. Ms. Santiago, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. Before I ask you some questions, and that's good, I'm glad that you raised about Bridgeway probation. With Ms. Santiago having mental health and substance abuse, if both of those say that she needs treatment, if she doesn't enter the Bridgeway program, is there any dual diagnosis that is available to her? Does she have to go down 2 different tracks at the same time? My understanding is that the success rate is better if it's done together.
Yes, sir. Patterson also offers substance abuse and mental health also.
Excellent. Okay, good. Thank you, ma'am. And so if Ms. Santiago enters Bridgeway, it would suffice for the time that she's there for both the mental health evaluation and the substance abuse evaluation, and also treatment during that time. But then if they require treatment after she gets out, she'd have to do that, correct?
Yes.
Okay.
Yes, sir.
Santiago, I say that for my benefit, where I know what I'm doing, but also for yours, where you know what you're required to do. Santiago, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did she answer all of your questions?
Absolutely.
Are you satisfied with her representation?
I love her.
Okay. Did you sign the plea agreement?
Yes.
Thank you, ma'am. She's wearing green for St. Patrick's Day.
Also, so we can match.
Yes. Very good. Okay. Ms. Santiago, I do accept your plea. You're adjudicated guilty. Your current supervision is modified so that the next year you'll be in community control. Then you'll have the balance of your supervision, your probation. You'll need to submit to a mental health and substance abuse evaluation within 30 days from your release from jail, and submit to if it's required, any follow-up treatment within 60 days. After that evaluation, the Bridgeway residential treatment will fulfill both of those obligations while you're there, but if you're required to be in continued treatment after that, you've still got to do that. You'll need to pay the $100 cost of prosecution, $150 public defender's fee. Also, the court, if you enter the Bridgeway residential treatment, the court waives the $40 per month cost of supervision. Good luck to you, ma'am. Thank you.
I'm sorry I'm jumping around so much today, Judge. I'm just trying to be as efficient with time as possible. If we can go back to Mr. Rice now. Mr. Rice's presence was waived by the court. That's why he wasn't transported today. Mr. Rice is still in the custody of the Okloosa County Jail. The court did sign an order allowing him to be released to his brother. Unfortunately, around the same time that the court did that, Mr. Rice's brother's elderly mother-in-law broke her hip, and he became responsible for caring for her. And he did not feel that he was able, because especially being out of state, to care for Mr. Rice and ensure that Mr. Rice followed all the orders of the court. So he was not able to sign Mr. Rice out as the court had allowed for. So basically, we're here today in 22 CF 843 and 856 for a status update. There has been no status change. I know that there have been no, the original hope was that some place would be found that Mr. Rice would be able to be released to. Unfortunately, based on the nature of the charges and the fact that they're still pending, there have not been any places that have been willing to take Mr. Rice. Just quickly, Your Honor, he was arrested initially on March 30th of 22, so he's essentially been sitting in the jail for a year without much progress on his case. Part of that was waiting on the court's order to get the evaluation done, and then the evaluation being done, and then subsequently a report being done. And then I'm sure the court recalls all of the kind of commotion with him being sent to, or ordered to go to Florida State Hospital, and then DCF objecting. Unfortunately, instead of allowing that appellate process to play out so we could get some direction from the appellate court as to what they wished for us to do in these situations, DCF withdrew their motion for a writ when the court essentially changed its order to releasing Mr. Rice pursuant to 3.212D as they had recommended. So we still don't have any real direction from the appellate court as to what to do. And so essentially I am going just to renew my motion to have these charges dismissed, Your Honor, and ask that the court dismiss the cases based on him being incompetent, remaining incompetent, and quite frankly, everyone exercising all of their ability to find another location for him to be placed without any success in the last year.
Yes, ma'am. So that's your renewing your emergency motion for release of defendant found incompetent to proceed that was filed on November 9th of 2022.
Yes, Your Honor, I did in that motion, just for the record, I did ask for alternative resolutions, either for the charges to be dismissed or for the court to allow him to be released pursuant to 3212D. The court chose to deny my motion to dismiss, but also to allow for release pursuant to 3212D. Unfortunately, because we don't have a substitute person to take custody of Mr. Rice, and his brother is unable to do so at this time, I am just renewing the portion of the motion that was denied and asking the court to dismiss the charges.
To the state?
Judge, the problem that we've ended up in this vortex going around and around is because initially the report that we had really didn't give clear guidance on whether Mr. Rice would be restorable or not. At this point in time, it's been a long enough passage of time since that first evaluation. The state would feel that at this point, the most appropriate would be to really be able to, figure out if the defense's assertion at this point that he is still incompetent to proceed, if that does still apply, by having Dr. McDonald do an updated report with Mr. Rice, and now that there's a little bit more background that she will have access to with their observations at the jail, as well as her, excuse me, and now another meeting with Mr. Rice, that she can give the court better guidance on whether he's restorable at this point or not.
And Your Honor, just to respond, the state is essentially renewing their request for a second evaluation, which they initially asked for in November prior to the court granting a bond, and then never actually contracted with anyone to get that evaluation done. So, my assertion would be to the court that they've had since November, when they initially stated they wanted to go ahead and get that second evaluation to be done. That was 5 months ago. That could have been done. And so I'm in a tight spot because I don't have a whole lot that I can do to assist Mr. Rice in progressing his case, other than to be up before the court arguing for the court to dismiss the charges so that he can be released. And I understand the state's position. I would not have objected to a second evaluation being done. I just would have asked that it had already been done, since he's been sitting there. I mean, the last evaluation was done in August, report to the court in September. They could have done it since September, and they've chosen not to. So I would ask that the court go ahead and grant our motion to dismiss at this time.
Judge,
The motion to dismiss respectfully is denied. I was reading through Dr. McDonald's prior report where she did the exam July and August of 22, and the doctor's statements of consideration for some form of dementia must be considered. That certainly isn't something that the court thinks the passage of time may help the defendant be competent. However, later in her report, she says Mr. Rice's ability to benefit from competency restoration appears fair. And so the motion for the second evaluation is granted. Ms. Jacob, you were kind of with kid gloves. You were saying that the second evaluation was never done. It sounded like, Ms. Davis, if you'll make sure that that second evaluation is done.
Judge, the difference would be, so the second evaluation that Ms. Jacob was referring to, that the state was asserting in November, it got stopped. That was going to be something that we were going to do ourselves, which would then require having a different doctor do the evaluation. So because the first evaluation was done as a court-ordered evaluation, then this would now allow Dr. McDonald to do the evaluation again. So that's why the state is requesting that the court do this, not the second evaluation that Ms. Jacobs referring to from before. That the brakes got put on that because of the appeal process going on. So that's a totally different scenario than what the state's requesting at this point. So.
That's correct, Your Honor, and the state had asserted they were going to get their own evaluation that they were going to pay for. This is essentially a second court-ordered evaluation. And the reason that I wanted to speak was because I know that one of the things that Dr. McDonald had stated was that without additional funds being released for neuropsychological testing, she would not be able to make or opine an opinion or come up with an opinion based on whether or not dementia was the reason that he was essentially incompetent to proceed. So is the court authorizing additional court funds to have that neuropsychological testing done? Because I know the court of the standard eval amount of money is not going to be sufficient to cover that testing.
I don't think I have that authority administratively. Ms. Davis, if you want to talk to well, or Ms. Jacob, if you're the one that's pushing for it, if you want to talk to court administration and ask them. I know that when there are certain expenses, there is a judge in Pensacola, Escambia County, that has to make determination on certain attorney's fees. I don't know whether the chief has designated that judge to make those determinations. But as far as I know, all of us don't have unlimited purse strings. We've got to get the okay from the chief. So if you want to pursue that avenue, I'd love for you to do it.
And quite frankly, Judge, I don't think that I can. My position here is that the second eval is not necessary. My concern, however, is I would ask that the state perhaps take that position and do that, because my concern is we are going to be right back here with the same kind of evaluation where he's incompetent, but we're not sure why, and without further testing, we can't say it's definitely due to dementia, although I think if the court recalls its observations of Mr. Rice, I think it's, from a layman's perspective, it probably is pretty obvious, but I know the court requires or is going to need some evidence of that beyond what our observations are.
Do we have an idea on the cost for that?
I can get a cost from Dr. McDonald pretty easily for the court. I just don't know that I can.
If you'll get me that cost, then I will ask the chief.
I will reach out to her today, Your Honor, and get that information to you as soon as possible.
Okay. Good. Thank you so much.
Thank you, Your Honor. And I will provide an order for the court, just kind of outlining the denial. Is that without prejudice to be renewed?
Yes, ma'am.
Okay. I will provide an order just so we make sure the record is clear.
Thank you.
And that's all I have today. May I be excused?
I think we'll need to schedule another update.
That's true. We will need to.
How far out do you want to set?
I think it might be prudent to go ahead and put it on the May miscellaneous, or maybe even the June miscellaneous date, to make sure we have a report back.
Let's do the last court date of April, just so that way, if for some reason she's able to get stuff done, or...
April 20th at 9 o'clock.
Great, Your Honor, and I would just ask that the court waive his appearance because I know logistically it's difficult on the jail.
I
And
do waive the
once I speak to Dr. McDonald, I'll also get an estimate of time from her so that if we need to move that hearing, we're not wasting time in the court.
Okay. Great. When you get me that information, then I'll ask the chief.
Great, thank you, Your Honor.
Thank you, ma'am. Mr. Kilpatrick. Good morning, sir.
Good morning to you, Your Honor. Keith Kilpatrick representing Mr. Jose Cabrera. He is in custody before the court, case number 21 CF 1101 and 21 CF 1365. The defense in both case numbers filed a motion to reinstate his bond, and we're prepared to go forward.
Okay.
Yes, sir.
Yes, sir. I did do my homework. I see, Mr. Cabrera, that that's the opposition. Let me go, and I saw the rest.
Your Honor, I have not received discovery yet, so kind of a little disadvantaged as far as the facts and stuff like that. But, you know, my client has been in custody since on or about September 23rd, 2022, where his bond was revoked. There was allegations that he took his GPS off and he absconded from the jurisdiction. And, you know, to address that, Your Honor, we would just say that whenever the GPS was placed on him, he was riding a bicycle and it got caught up in his spokes, and it was actually taken off that away as far as that goes. And then he subsequently then got homeless. During this time, the state filed an objection to the reinstatement and alleging that there needs to be some sort of substantial change of circumstances. And I've done my research and I haven't seen that there is a standard for bond modifications. And if the court is looking for any type of change in circumstances, I think by the nature of my client being in jail since September 23rd, 2023 or 2022, that alone is a change in circumstances. But he has, while he has been in custody, has secured a home. He's going to be living with his mother at 130 Fetting Avenue for Walton Beach, where he is going to be working full-time at Queen's Painting. His fiance actually owns the company. She is present today to testify to assure the court that she is going to be back behind her fiance and making sure that he's going to show up to every court date. He is at this time just turned 20 years of age. He was essentially 17 when these allegations came about. But he has retained private counsel. I am there again going to assure that he shows up to every court date, keep in contact with him, etc. And like I said, he's got several family members that are local in the area, young brothers and his mother, which has lived at the 130 Fetting Avenue for some time. At this time, Your Honor, I would like to call Carolyn Hernandez.
Ms. Hernandez, if you'll please
She
come
present, she approaches the lectern. Would you step over here?
No, she's still here.
Oh, gotcha.
You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes.
Please state your name for the record.
Carolina Hernandez.
Okay, and what is your relationship to Mr. Cabrera?
I am his fiance
Okay, and how long have you guys been engaged?
for about a year already.
Okay, and where do you reside?
Excuse me?
Where do you live?
I live in 103 Fetty Avenue, Lot 4.
Okay, the Fetting Avenue. And who else lives there with you?
It's just me and him for
Okay.
now.
All right. Is his mom going to be living there as well?
Yeah.
Okay. All right. And during I guess your fiance, do y'all work together?
Yeah, we work together.
Where do you work?
Queen's Painting.
Okay, what do you do?
We do painting and cleaning, and we have a lot of jobs.
Okay. And will your fiance, Mr. Cabrera, be working with you?
Yes, sir.
Okay. All right. And you said you have plenty of jobs right now
Yes, sir.
to keep him busy?
Yes, sir.
All right. Are you going to ensure that he shows up to any and all court dates?
Yes, sir.
Okay, and how are you going to do that?
Well, the way I'm gonna do is to like make sure he shows up in time. I'm gonna be 100% responsible for him.
Okay. And do you have any criminal, have you ever been arrested?
No.
No. Okay. I have no further questions, Your Honor.
To this state?
Mr. Hernandez, do you have any children?
None of my children live with me.
Where do your children reside?
My youngest son, he's in Puerto Rico, Cataño. My two older kids, they live in South Carolina, Lufkin, South Carolina. And my 8-year-old, she lives in North Carolina, in Fayetteville.
No further questions.
I have no further questions, Your Honor. Does the court want to inquire?
No, sir, I'm good. Thanks, Mr. Hernandez.
You're
Thank you for
welcome.
being here. You can step down. Mr. Patrick, any other evidence?
No other evidence, Your Honor. Just the fact that, my client is so young, he's in jail, he's got an opportunity to go out in the community and be productive. He's been in jail since September 23rd of 2022. During that time, he's not been able to be productive. And I have just recently got on this case. I'm actually, looking at all the discovery and all the evidence in it. And we're going to try and move this as soon as we possibly can, but it's going to be a little bit, obviously, given the nature of the offenses.
Yes, sir.
So we'd ask for a reasonable bond.
Ms. Barrett?
Judge, I know you noted that you've had an opportunity to review state's opposition to the bond.
Yes, ma'am, I did, and I also have the addendum to probable cause, and I went through that.
Okay. First of all, Mr. Cabrera was already given a full-blown bond hearing in which the defendant and his wife testified on January 17th, and that request was denied. His current bonds are revoked due to the FTAs and contempt of court. The first case was a CJ case originally. It was for the defendant soliciting a 13-year-old for sexual conduct. That's 21 CF 1365. However, 21 CF 1101 was always filed in adult court, and that was using a computer to solicit a different minor in lieu of lascivious battery. And that was another 13-year-old, a different victim. And we would point out that these are not undercover cases. These were both live victims. On May 4th of 2021, he was given signature bonds with GPS and pretrial conditions. That GPS was placed at the jail May 6th, and he was released. He cut or removed the GPS monitor the very same day, and he was not picked up until September of 2022, over a year later, and he was arrested on those warrants in Alabama. He's already shown that he cannot comply with the court's orders, and he remains a huge flight risk. In addition, those outstanding warrants were out for over a year. We have not filed on any FTAs or tampering with electronic monitoring device charges at this point to give the defendant a chance to enter some sort of a plea. In accordance with Marcy's law, we attempted to reach out to the victims regarding this bond hearing. The victims in 1101 do not want him to get a bond and are frightened that he would contact them if he were to get a bond. We would note that he did contact JC and her family during the investigation and were warned away from doing that by Detective Zabowski. He tried to work something out with the victim's father, and that's in 21 CF 1101. So state's position is he was and remains a huge flight risk, and he has demonstrated that he cannot or will not comply with the court's orders. So we ask the bonds to remain as previously set and or revoked.
And I did read through your motion. Mr. Cabrera, after his GPS monitor ceased to function, or ceased to be on him, when was the expiration of the year that he was arrested? When was he arrested after the GPS monitor? I mean, just approximately.
So
Year?
September of 2022 was when he was arrested on the FTA.
And that's when he went into the jail.
Yes.
That's correct, Your Honor. And one thing that should be noted, Your Honor, that the prosecutor, she brought up is that he was, I guess, outside, out of custody, essentially, off bond or whatever. He didn't commit any new law violations. He was picked up merely because of the allegations of this case. He didn't get arrested for something else. And I think that that should be noted by the court, that he wasn't out there picking up new charges.
Mr. Cabrera, that works in your favor. The thing that doesn't work in your favor is you were ordered to wear and I don't want you to say anything factually about your case because the state can use it against you, but I want you to understand my logic. The GPS monitor was ordered to be worn by you. No matter how it came off, you didn't wear it for a year allegedly, and based on that, respectfully, your motion to reduce bond is denied. So when will I see Mr. Cabrera next?
Judge, he is set for, I believe, your docket day. However, I've since tried to secure all of the discovery. I have not received that. I'm thinking that if we could just go ahead and continue to the next docket day, I'll be able to secure all that information, and hopefully we'll be ready for trial on that next date.
Okay, so May 8th, I'll see Mr. Cabrera here. Thank you, sir.
Thank you so much, Your Honor.
Mr. Nettle?
Good morning, Judge.
Good morning, sir.
Douglas Spence, I'm sorry.
Yes, sir.
Judge, we're before the court this morning on a motion to modify his bond. Mr. Spence's bond is not that significant. It's $5,000 on each count due to a prior failure to appear several years ago, more than 20 years ago. None of the local bondsmen will agree to post his bond. So what we're asking is that the judge modify his bond to make it a signature bond with pretrial release, even an ankle monitor, whatever the court sees fit. But as it presently stands, no bondsman will touch Mr. Spence's bond, even if he had the money to pay the $1,000, the 10% fee. That no bondsman will agree to post it. So,
I understand. To the state? Mr. Spence's case?
Yes, Judge, just give me 1 second, apologize. Judge, on both the register counts, he scores 77.85 months, Department of Corrections. His priors include rape of a minor, 2 FTAs, battery on law enforcement, and an escape that was pled down from evading arrest, and 2 prior failure to register cases in 2016 and 2012. So based on the totality of the circumstances, including his prior history, we believe the bonds are appropriate as set. However, if the court is inclined to release him, given his FDA and evading arrest history, as well as the fact that there was a victim who was 14 years of age in his underlying sex offense, he would qualify for the Jessica Lunsford Act, so we'd ask for GPS of $1 per day.
Judge, he was not convicted of a rape. It was a statutory rape. It wasn't a violent rape. It was he had sex with a girl who was under the age of 16, and he was. That was in Tennessee. That was in 2005. That's how he wound up in this status that he's in. And incidentally, if he had remained in Tennessee, he would have only been on the SO list for 10 years. Here in Florida, it's a lifetime commitment. So that's one of the problems. He would like to go back to Tennessee at some point and get taken off this list. But it is what it is. He was on the list here, and we've been trying to work out an agreement. I mean, because of the level of this is a felony 3, but it's a level 7. I think it's the only felony 3 in the state of Florida that is a level 7. I mean, he could have used a gun in several offenses and had a lesser score than what he's getting for this particular offense. And because there's 2 counts, that's why he's scoring 77 months.
Mr. Miller, how long has Mr. Spence
He was arrested on 9/30.
How long has he been in Florida?
When did you move to Florida, Mr.
2010, 18?
2010.
And 10.
I've lived in Shalimar.
Thank you, sir.
I've
So, Mr. Spence, here's what, when I was doing my homework, the second to the last paragraph of the warrant, the affidavit says, the defendant has shown a history of failing to register He was previously convicted in 2012, 16, and 17 for similar offenses.
I think he's got 2 prior convictions. The warrants.
When they say similar offenses, is that similar offenses failing to register?
Yes, he was convicted of failure to register. I think it was 2012. He was placed on probation. He did violate the probation a couple times, but he successfully completed it.
And he was sentenced to the Department of Corrections.
Right. Then the last time he
wasn't released until March of 21.
Correct. He was, the second time he was convicted, he was put on probation, which was violated, and then he wound up going to prison for 5 years. So he just got out
Understand.
a year and a half ago, or so, or less than a year, actually about a year.
Mr. Spence, it's hard for the court to find any justification for why you failed to register for 10 days after getting out of prison for failing to register. So respectfully, the motion is set. And also, I do acknowledge the understanding that if you had money, you would post the bond yourself and you'd be out. And that's something that rips at every judge. But based upon the allegations, I don't find a valid reason for reducing the bond. So respectfully, it's denied. So when will I see Mr. Spence? Will I see him on docket day, Mr. Nettle?
We haven't set another date yet. What is it you want to say? Just want to put it on the record. Tell me what you want to know.
I came to the jail if I just came.
No, that's about the facts of your case. We don't want to, the judge doesn't want to hear facts. Basically, he turned himself in the last time for a suspended sentence, is what he wants to let the court know. That he did turn himself in. He was released and turned himself in.
And when was that?
And
2017.
when he went to prison, he was given a suspended sentence, and they gave, told him to report, and he did report.
Yes, sir.
And the other thing he wants to advise, there was some effort on his part in this case to report, but it didn't comply with the statute. The statute gives him 48 hours. He was served an injunction to protection order. He had to leave the place he was at.
I saw that.
He didn't have any place to go. He thought if as long as he didn't stay anywhere more than 48 hours, he would be okay, which is not the case. If he has 48 hours to give them a new address or register as a transient, and he did not do so within the 48 hours, although he did later register after after the police came out and talked to him. He did attempt to go register, but it was too late.
And that's the address that I'm still on release at this present time. I've done a lot more, and I've put a lot of effort. Just leave a hand up, not a handout. That's all I add.
To the state. Mr. Spence gets some traction with, I did see that he was, he had to leave because of the injunction.
Which was dismissed.
Any evidence that in those 10 days he tried to communicate? He's saying that he didn't know that he needed to register because he didn't have a home for that period of time. Let me answer my own question as I talk. I apologize to y'all, I'm an extrovert, so I think while I'm talking, which drives the introverts crazy, I'm sure. Mr. Spence, my ruling stands. I'm not going to reduce your bond. I think that I'll see Mr. Spence back here on May 8th unless you set a hearing before that date. Thank you,
All
sir.
right, that's fine, Judge.
Thank you.
Hopefully we'll be able to work something out from this thing. Maybe. Well, I'll get to see you when I have.
Mr. Stevens, are you ready?
I have one case in the docket this morning. It's Michael Wayne Rogers and 22 CF 3127. As the court will recall, he indicated at pretrial that he wanted to enter an early plea in this case. I have not had a chance, obviously, to receive discovery and go through it. Mr. Rogers still wishes to enter a plea because it gets him out of jail today. So in 22 CF 3127, count 1 will be his plea as charged. Adjudication will be withheld. He'll be sentenced to $615 in court cost. He'll be sentenced to 2 years probation. There is a legal assistance fee. He'll have no trespassing at Professional Car Wash at 490 Mary Esther Boulevard, Mary Esther, Florida. He'll do 25 hours of community service work. There's $1,200 in restitution, which will be joint and severally liable with all co-defendants, and he will write a letter of apology to the victim. Count 2 will be adjudication withheld and credit for time served.
Thank you. Mr. Rogers, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. So, Mr. Rogers, what Mr. Stevens started with wasn't just filibuster, wasn't just something to say, but it's to put the court on notice and make sure that I say to you understand that Mr. Stevens hasn't had any discovery, so he can't advise you of any defenses that you may have that may arise from that discovery. He hadn't done a heck of a lot of work to prepare for your trial and give you that advice. So if you enter this plea, you're waiving that. Do you understand that?
Yes, Your Honor.
Mr. Rogers, did you read the plea agreement?
I read it to him.
Okay. Do you understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes, I did, Your Honor.
Did he answer all of your questions?
Yes, Your Honor, I did.
Are you satisfied with his representation?
Yes, Your Honor.
Mr. Rogers, I do accept your plea. Adjudication is withheld in both counts. You're sentenced to time served in count 2. Count 1, you're sentenced to 2 years probation. You'll need to pay the restitution of $1,200. That's joint and several with the co-defendant. We'll need to do a letter of apology. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. $150 public assistance fee. Have no trespassing at that car wash. Perform 25 hours of community service work and pay $40 per month cost of supervision. Thank you, Mr. Rogers. Good luck to you, sir.
With the restitution, would the court consider waiving the cost of provision for the first year?
Yes, sir, I will. Good.
Yes, sir. Thank you.
And that's all I have, Judge. Thank you.
Thanks, Mr. Stevens. Mr. Stewart, are you ready?
Good morning, Your Honor.
Good morning, sir.
May it please the court, Your Honor, Brad Stewart present. On behalf of Matthew Watucky, Judge, this is case numbers 21 CF 1869 and 22 CF 672. Your Honor, we're also disposing of 2 misdemeanor cases as follows, Madam Clerk: 22 MM 464 and 23 MM 184. Your Honor, at this time, Mr. Watucky is prepared to admit the violation of probation and enter a plea of no contest on the misdemeanor charges, with the understanding, as it relates to the violations of probation before the court, probation will be revoked and terminated. He'll be sentenced to 9 months Okloosa County Jail. That's concurrent across both cases and all counts, with credit for all time served. There will be 100 plus 100 VOP fee, financials paid within 180 days. The misdemeanors will be time served with $250 in costs payable within 180 days of release. Your Honor, may I approach?
Yes, sir.
Let me pause one moment, Judge. I apologize. Mr. Watucky does need to sign a previously reviewed written plea agreement. It's the same one. Your Honor, may I approach?
Yes, sir. Thank you, sir. So, Mr. Stewart, let me make sure I understand. The 9 months is going to be concurrent in each case and count, including the misdemeanors?
Not to include and exclusive of the misdemeanors, Judge.
The misdemeanors are time served,
Time served.
and then you were appointed to represent Mr. Watucky in the misdemeanor cases also?
That's correct.
And so what are the attorney's fees in misdemeanor cases? Are they 50? Okay.
Judge, I do need to tell Mr. Watucky that he does have those additional fees. I did explain that to Mr. Watucky, Judge. He does understand.
Okay. Mr. Watucky, if you'll please raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. So here's what I've got, Mr. Watucky, just to make sure that we understand and that you understand. If I accept your plea, you would be adjudicated guilty. Your prior supervision would be revoked and terminated. You'd be sentenced to 9 months in Okloosa County Jail in each case and count on the felony cases with credit for all time served, which would run concurrently, run at the same time. You'd be sentenced to time served on the misdemeanor cases. You'd have to pay a total of $200 in violation of probation fees, total of $350 in attorney's fees. You'd have 180 days after your release from jail to pay all outstanding financials, or they would go to a civil lien or judgment. Is that what you wish to do? Mr. Watucky, do you understand? Well, did you read the plea agreement?
I did, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes,
Mr. Watucky, I do accept your plea. You're adjudicated guilty. You're sentenced to 9 months in Okloosa County Jail with credit for all time served, and that's to run concurrently on each count in the felony cases. Sentenced to time served on the misdemeanors. You need to pay $200 in VOP fees, $350 in public assistance fees, attorney's fees. You'll have 180 days to pay those amounts, or they go to a civil lien or judgment. Thank you, sir. Good luck to you.
Your Honor, that's all I have before the court. May I be excused?
Thank you, Mr. Stewart.
Thank you, Your Honor.
I don't see Mr. Woodward. MC Carter. MC Carter. Hello, Mr. Carter. I'm doing well. How are you? Good. 19 CF 741. Does the state have an offer for Mr. Carter?
Your Honor, I think right now the only, the main issue for us is that we just want the restitution to be paid. There's still an outstanding amount of $1,123. We would be willing to extend the probation on this particular case to allow for that to be paid.
How long do you intend to extend it or offer to extend?
I guess I would want to ask the defendant about how long does he think that he would need to pay that. I mean, if he knows that he's not going to pay it, then we can make some sort of other offer that would hopefully resolve the case. But if he has the ability to pay, we would like him to pay.
Okay. Mr. Carter, before you say anything, if you say anything factually about your case, it can be used against you. You have the right to an attorney. If you qualify financially, I can appoint one, but it'll cost you $150. So just know those two ground rules, okay? If you want me to appoint an attorney, I can. If you don't want an attorney at this point, and you want to answer the state's questions, know that if you say I didn't pay the fees, or you acknowledge that you're admitting the violation, and it can be used against you. So what would you like to do?
Good morning, Your Honor.
Good morning, sir.
First of all, I had a year of probation, and I didn't pay my my court costs, and I asked, and the year was up, and I asked you, could I have a year extension on that to do community service? I did 100 hours community service on that, completed it, and here I am.
Okay. But the 100 hours of community service was to work off court cost, right?
Right.
And we're talking about restitution, the damages to the victim.
Well, it's restitution payments to J-Pay. That's kind of a different thing to me, but they have categorized it as restitution payments in the affidavit.
So it's not restitution.
Right.
I mean, it says restitution payments to J-Pay. I'm wondering if there might be some sort of...
Do you mind?
Your Honor, I
Yes, sir.
represented Mr. Carter
Good.
originally. I do not recall any restitution. This was a controlled buy situation that I don't recall there being any restitution in that.
Okay. So if Mr. Carter worked off to probation, do you have anything you can enlighten the court with?
No, he does not owe any restitution, his court costs.
Okay, and did he get credit for his community service work against those court costs? Mr. Carter, I'm glad you raised that because there's a huge difference in the court's mind between restitution and everything else.
You know, I do not see where the community service hours were entered.
Okay. Mr. Carter, I think you need to get with your probation officer, provide them proof of what you've done, and get credit for that, and then let's see where we are. Okay?
Okay.
Do we want to continue the hearing for a month, and you get with probation?
I can get with them sooner than that, Your Honor. I got the paperwork where I
Do
completed.
you have it now?
Not only, I didn't think it'd bring it.
Okay. The next miscellaneous date I have is April 10th. So I'll see you back here April 10th at 9 o'clock and just continuing this hearing. Get with probation, talk to them, tell them everything, okay?
Okay.
And then let's see where we are. If probation says you've already done everything, then the state presumably will drop the violation of probation and it'll be gone.
Okay.
Okay?
That's good.
If not, I'll see you back here April 10th. at 9.
April 10th.
Yes, sir.
Okay.
Thank you so much.
All right, thank you.
Next is Tyler Hale, 21 CF 3143. Tyler Clayton Hale. I don't see Mr. Hale. This was noticed for 9 o'clock. It's now 10:10. What is the state seat?
Capious, Judge.
A capious will be issued for Mr. Hale, and the first appearance judge will determine the bond. That means that they'll put Mr. Hale in jail and bring him before the court, so we appreciate y'all being here. Next is Joseph Hallcroft, 21 CF 2063. Hello, Mr. Hallcroft. Good morning, sir. Does the state have an offer for Mr. Hallcroft?
Judge, my understanding, Mr. Hallcroft, that he was doing the 12 Oaks treatment facility?
Yes, ma'am. I'm currently a resident there.
At this point, Judge, in exchange for an admission, we'd asked for an adjudication, which I believe he was adjudicated on the felony charge, but it was a withhold for the 2 misdemeanor charges. Then modify his supervision to include successful completion of the 12 Oaks residential treatment program, $100 cost of prosecution, and remove the early termination provision.
Okay, so how long was the original term of supervision?
It's 2 years, but he had an opportunity to automatic early term at 12 months.
Okay. So, Mr. Hallcroft, do you understand what the state's offering?
Yes,
Be an
sir.
adjudication of guilt of the felony and the misdemeanors, and it would be modified so you have to successfully complete the 12 Oaks inpatient treatment, and you'd have to serve the full 2 years of probation, and you'd have to pay $100 cost of prosecution.
Yes, sir.
Is that what you wish to do?
Yes, sir.
You'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. So, Mr. Hallcroft, do you understand if I accept your plea that you're waiving your right, basically a judge trial where the court has to determine if you violated probation?
Yes, sir.
Do you wish to enter the plea?
Yes, sir.
Mr. Hallcroft, I do accept your plea. You're adjudicated guilty. Your current supervision is modified so that you'll need to successfully complete the 12 Oaks inpatient treatment. The early termination provision is removed, and you'll need to pay the $100 cost of prosecution.
Yes, sir. And I'm also, I'm actually staying for 90 days, and then I'm going to do a 6-month halfway house after that. So just, I mean, on my own accord.
Okay. While you're in 12 Oaks and you're in the halfway house, if you show that proof to probation, then the court waives the cost of supervision while you're in there.
Yes, sir.
Okay.
Yes, sir. Thank you.
Just to remove any confusion, there was originally a substance abuse evaluation and a recommended treatment. If we can remove that provision as well, since
Okay.
he's doing inpatient.
Okay. So that provision's also removed.
Yes, sir.
Thank you, sir. So are you still in 12 Oaks? Or
Yes, sir. I thought that my court date was on the 6th, so I came from Gainesville. I live in Gainesville now. So I came from Gainesville on the 6th, and I don't live here anymore. So I had already made plans to go to 12 Oaks through the VA, and I went ahead and went, so I could get my life back on track.
Good for you.
Yes, sir.
Thank you, sir. The best.
Thank you.
Thank you,
Good day.
sir. Megan Leon is next. 20 CF 2633. Hello, Ms. Leon. Does the state have an offer for Ms. Leon?
I think at this time we would be willing to, there's some outstanding court costs, we would be willing to revoke and terminate the supervision and send all court costs to collections if that's what you would like to do.
Okay, so Ms. Leon, here's what I hear is that the state's willing to revoke and terminate your supervision today. You'd have a period of time to pay the court cost, or they can go directly to civil lien or collections, which may adversely affect your driver's license. So I don't see much of a downside to that. How long will you need to pay the court cost before it goes to a civil lien?
Well, I paid about $600 yesterday. I owe $74, so I can pay that today.
Okay. So, and she would be admitting, what would be the adjudication?
If I'm not mistaken, I believe she had a withhold on her original, we would maintain the withhold.
Okay. If, Ms. Leon, if I continue the hearing until April 10th and she pays that off before the 10th, then would you just dismiss the VOP?
Yes, Your Honor.
Okay. Why don't we do that? Then I'm not saying withhold of adjudication and all those things. Your case would just be fulfilled. Okay?
Thank you.
So April 10th at 9 o'clock, if you haven't paid everything and the case isn't dismissed. If you pay everything and the case is dismissed, you don't have to come back. Okay? Thank you. Okay, we did Ms. Jacobs. Mr. McKinney? Well, I think you're next, or Mr. Klein's is next.
Your Honor, I was going to ask if I could just jump in, because I have two people, and that's it on the morning docket.
Okay, yes, sir.
In custody, I have Benjamin Lee.
Mr. Lee?
No, just Mr. Lee.
Do you want to take the person?
I can take the person, Mr. Terry McMullen. He's on the 130 docket, Your Honor, for arraignments, but he's present. In the case number here would be 23 CF 250. And there is information was filed on February 15th. We will acknowledge receipt of the information, waive the formal reading, enter a not guilty plea. Mr. McMullen's already on the May 8th docket, and his case is already in my deposition pipeline. So I don't know if we'll have him taken by May 8th, but we're already in the process. So we'll just enter the not guilty plea and leave him on that May 8th docket.
Mr. McMullen, I'll see you back here on May 8th at 9 o'clock. Okay? Thank you, sir.
Just step out from the lectern for the sir.
Your Honor, this is Mr. Lee. I met with him at the jail yesterday. When I get to the office this morning, I'm going to be filing a motion for furlough. The problem that I ran into was between Monday and Tuesday when I talked to the jail. Mr. Lee's father had actually passed away, so he's got a funeral this coming Saturday. So I talked to Mr. Gomez, and I've talked to Mr. Lee's aunt, and so I've got the details for that. I didn't have that until yesterday afternoon when I was at the jail. So I'm going to come back at 1:30 with a motion and the order, proposed order. We'll see what the state has to say, but if we could just pass Mr. Lee to the 2:30 docket.
Yes, sir. So to the state, you want to see that motion before?
To be quite honest, Your Honor, I'm not going to make somebody prove that they're going through that, so we would stipulate to the furlough to be able to get him out to be with his family.
Okay. So, Mr. Lee, when do you need to get out? How long do you need to stay out?
My intent, I don't mean to
No, go
step
ahead.
into it, but I talked with him yesterday.
Because if I asked Mr. Lee, he'd say, I need to get out now and come back in a year.
Today is great.
Yes,
I was going to propose like a release tomorrow at noon in case he has to sign any paperwork. He's the only heir to his father's estate. And then my intent was going to be to ask the court to allow him to report back to court at 9 o'clock on Monday morning, so he can address anything that he has to tie up family-wise.
Any objection from the state?
No objection, Your Honor.
Mr. Lee, I'm sorry about your death.
Thank you, Your Honor.
So they'll release you at noon tomorrow, and I'll see you back here at 9 o'clock on Monday, okay?
Yes, sir.
Thank you, sir.
And so we don't need to have him back at the 2:30 docket. I'll just come back with an arraignment with an order.
Correct. And Mr. Lee can be released based on the minutes.
Okay.
For that, for
Judge, we would like to say, I think upon his release, we don't want any consumption of alcohol, drugs, or anything like that.
100%. We'll put that in the order too.
Good.
Absolutely.
And so they may test you when you get back to the jail, so don't do any alcohol or drugs between now and when you come back.
Yes, sir.
Thank you, sir.
That's all I have on the now. I need to excuse.
Yes, sir. Thanks, Mr. Prince.
Judge, may I call out of order since Mr. Sanchez is here? And that's Cecil Rowell. Mr. Cecil Rowell is approaching in 22 CF 585. Judge, Mr. Rowell has previously been before the court and previously been found to be incompetent to proceed. And the goal here is for a conditional release plan. And since Mr. Rowell has an existing history with APD, Mr. Joseph Sanchez is actually present in the courtroom from APD, and he's helped me work on a conditional release plan. We do have that plan signed by Mr. Rowell. I have reviewed it with him. The state has reviewed the conditional release plan. So has Mr. Sanchez, who's present in the courtroom if the court has any questions. The court would need to accept this before I'm able to provide an order adjudicating him incompetent to proceed and placing him on conditional release. I will have to amend some portions of the order. Normally in an APD situation, the court would likely say, hold on, you haven't appointed an APD expert. You need to do that. In this situation, because Mr. Rowell has an existing history with APD, we can go straight to the conditional release plan with Mr. Sanchez. May I approach with that document so the court can review it?
Yes, sir. Ms. Barrett, anything else you want me to know?
Your Honor, the only thing that we believe would also need to be addressed would be the pretrial conditions that were already placed on him, but we have no objection to the report as.
Okay, thank you. Okay, it says to follow the terms of my treatment plan. Okay, good, and it's from his perspective.
Correct.
If Mr. Rowell is not competent to proceed, but he's competent to understand what's in this contract, basically?
He has to acknowledge the conditional release plan provided to follow the conditional release plan. He has to be advised of what it is. And the individuals that helped Mr. Rowell are here and helped me explain that to him. Mr. Sanchez is also present in the courtroom if the court has any questions of him. He would be reporting directly to Mr. Sanchez and starting conditional competency restoration with Mr. Sanchez on
Mr.
Mondays at
Sanchez,
3.
if you don't mind coming into the lectern. Thank you, sir. Mr. Sanchez, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Mr. Sanchez, so have you gone through each of these paragraphs in the conditional release plan with Mr. Rowell?
I actually sat in on the conference with the attorney and his support coordinator.
Okay,
And they
so,
reviewed,
go ahead, I'm sorry.
when they reviewed the
Okay. And they went through all of these terms with him?
yes.
Okay. And you believe that Mr. Rowell understands them?
I believe that he acknowledged them.
Okay.
Yeah.
Okay. Mr. Rowell, do you have any questions for me or for Mr. Sanchez or Mr.
No, sir.
Okay. It's good seeing you again. You're always good-natured when you come before the court. So I do agree to the conditional release plan. You have to do these things, or then you report back in front of me and give up some control. So make sure that you fulfill this plan, okay?
I will.
And follow what is asked of you. Thank you. Yes, sir.
Judge, the plan will start with Mr. Sanchez on Monday at 3 p.m.
Yes.
In Pensacola. I've explained that to Mr. Rowell. I can provide the court with an order formally adjudging him incompetent to proceed and place him on the conditional release plan that you have.
Yes, sir.
No later than today or tomorrow.
Okay. Good. Thank you. Thanks, y'all. Good seeing you again, sir.
Good seeing you too.
Your Honor, the only thing that I would request that they remind the defendant of is his pretrial conditions. Those are all still in place, including the GPS, no internet access, no unsupervised contact with minors.
Yes, ma'am. So, Mr. Rowell, you'll still have to wear the GPS monitor, okay?
Okay.
And you have no internet access.
Judge, and we may be getting ahead of ourselves here, but if Mr. Rowell does well in following Mr. Sanchez's orders, we could always revisit the GPS monitoring at a later date by motion.
Yes, sir. Absolutely. So that's not for the rest of your life. Do well, and then Mr. McKinney can come back before the court, and we'll talk about it, okay?
Okay.
Good.
Take care.
So I will submit that order to the court, which is the last piece of the puzzle before he would likely come off the docket. Does the court want to set a status date to make sure that that order is submitted and signed, or does the court just want to leave it as it is?
Probably let's set a status date.
Okay.
On just April 10th.
That's fine, Judge, and I have the order here. I need to maneuver some of the language before I submit it to the court. I'll do that
Do you
today or
need
tomorrow.
your plan back?
Nope, that would be submitted for Madam Clerk.
Good. So, Mr. Rowell, I don't think you'll have to be back here, but if something goes sideways, something goes wrong, then I'll see you back on April 10th at 9 o'clock. But stay in touch with Mr. McKinney, and he'll let you know, okay?
Okay, I will.
Then we'll follow
Thank you,
the
sir.
time starting on Monday.
Okay.
All right. Thank you, Judge.
Thank you, Mr. Sanchez, for coming from Pensacola.
Yes, sir. Thank you so much, Mr. Sanchez.
You're welcome.
Since we've been working an hour and a half, we'll take a 10-minute recess, and then we'll come back and finish up the morning.
All rise, please.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February from 10 until Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Mr. Fisher, you're charged with dealing in stolen property, that's why you're here. Do you wish for me to appoint a public defender if you qualify financially? Yes. How much money do you make per month? Around 1,000 or 1,500? Okay. I do appoint the public defender to represent you. Mr. McKinney's going to put you on your back.
Yes, I provide my contact information at this time. Now we'll acknowledge the receipt of a one-count information waive this formal reading and will plea of not guilty. The scheduled court date is May 8th at 9 a.m.
Okay. Mr. Tercero, I'll see you back here May 8th at 9. Stay in touch with the public defender. Thank you.
Judge, for the record, it's a withholding 1-year probation with some other terms.
Thank you. Talk to me about
Thank you. Okay, who else is in the gallery for the 130 docket? Any other defendants in the gallery?
Come on. If you're here for court, just go ahead and make a line. If you're here for an inmate, go ahead and just wait. Sir, go ahead and step forward. Your name?
Samuel Reeves.
Reeves, are you on the 130?
Hey, it said 9 o'clock on my paper in it.
Okay, good. Well, shuffling around the fire.
What's the name?
Reeves, Samuel Reeves, in the kitchen.
Yes, sir. 23 CF 234. Does the state have an offer for Mr. Reeves?
Judge, the offer had been for a PTI. It looks like Mr. Reeves does not have any prior history. So it would be, obviously there are some terms and conditions of pretrial intervention that I'm not going to go through right now, Judge. But it would be the $100 cost of prosecution, the public defender fee if applicable, and then 15 hours of community service work.
Okay, so how can Mr. Reeves who can bring him up to speed on what the terms of PTI are?
If that's something that he would want to do, then I can get his email and my assistant would send him a copy of the agreement.
Okay. Mr. Reeves, so what that is pretrial intervention. It means that it's a diversion program. If you successfully complete the terms of that contract, then your case is dismissed, so it diverts around this court. So pretty dang good outcome
Yes, sir.
if you fulfill those things. So I'd recommend that you at least look at that and then decide if you want to do it, and that we just continue your hearing from today.
Okay.
If that's okay.
Yeah.
Okay. So, and I'm sorry, you're charged with possession of a controlled substance without a prescription and possession of paraphernalia. That's why you're here. Let's just continue the hearing until the next arraignment that I have. March 23rd, is that going to be too soon?
I don't know that he would have time to get the paperwork, and he would have to go to probation and speak with officer of arrest before it would be entered with the court.
Okay. Mr. Reeves, let's set it for April 13th at 9 o'clock. So I'll see you back here April 13th at 9 o'clock, unless PTI says that you're accepted and that you've dropped off the docket. Okay?
Thank you.
Thank you, sir.
Sir? What's your name?
Fred Kong, C-O-N-N.
Thanks, Mr. Khan. Mr. Khan, were you on the 1:30 docket meeting? Must be. Must not. Oh, you're on the 9 o'clock docket, number 10 on mine, and it's for a motion. And Ms. Barrett, and it's your motion.
Yes, Judge. The victim's family in this particular case are asking that the sentence be modified from no contact with the child victim to no contact with the victim or the victim's family. We attached the sworn statement from the victim's mother as well as the screenshots in this particular case. So based on the witness statement, state would request no contact order be extended to the victim's family.
Okay. Mr. Khan, do you object to that?
No, I do not, sir.
Okay. Then the motion to modify sentence is granted, so you don't have no contact with the victim or the victim's family directly or indirectly. Don't post anything online directed at them.
Yes, sir.
And so we'll get you that modified order. Okay. Thank you, sir.
And for the record, that would be John and Crystal Griffin and their other children.
Okay. Thank you.
No, thank you.
Thank you, sir.
They are here for inmates.
Yes, ma'am. Good.
Alright, I am going down the docket, females first, Alessandra Bateson.
Any questions on?
Ryan Morrow for Ms. Eitzen, Your Honor. This is 21 CF 2092 Alpha. The agreement between the parties contemplates an admission of the VOP, but asks the court maintain the withhold adjudication on the underlying charge, reinstate original terms and conditions of the probation with an added condition of completion of the Road to Recovery program, where she's been accepted to. $100 VOP fee, $150 cost of defense, and $148.16 cost of transportation to the Okloosa County Sheriff's Office. If I could take a moment to get a signature from my client, I'll approach with the written agreement.
Thank you.
And this is bars to beds, I believe, Your Honor. May I approach?
Yes, sir. Thank you. Thank you, sir.
Sorry.
How you pronounce your last name?
Eitzen.
Thanks, Miss Eisen. Miss Eisen, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You can put your hand down. Miss Eisen, did you read the plea agreement?
Yes.
Do you understand it?
Yes, after the road to recovery program, then I'll continue to be on probation for
Yes.
2 years.
Correct. The balance of your probation will continue. Right?
Do I have to pay the probation cost while I'm at rehab?
I will waive that while you're in there.
I would have asked, Your Honor. Thank you
Great
very much.
question. Good. Ms. Eisen, so you read the plea agreement?
Yes.
And you understand it?
Yes.
Did you discuss it with your attorney? Did he answer all of your questions?
I think so, yeah.
Okay. Are you satisfied with his representation?
Yes.
Did you sign the plea agreement?
Yes.
Ms. Eisen, I do accept your plea. Adjudication is withheld. Your current supervision is modified so that you'll need to enter and successfully complete the road to recovery. You'll remain in the jail until a bed becomes available for that. You also need to pay the $100 cost of prosecution, $150 public defender's fee, $148.16 cost of transportation. That'll be during your supervision. The court does waive your cost of supervision while you're en road to recovery and also while you're in jail, if that applies there. Thank you, ma'am.
Thank you.
Question?
So road to recovery has to pick me up, or could someone else bring me from here to there if they have a bed available?
As long as you're going straight to road to recovery, I don't know if they physically come and pick you up or if somebody.
I haven't dealt with road to recovery specifically, Your Honor. My experience and expectation was that it would be bars to beds and that they would need a person from road to recovery to come and collect her. But if the court is comfortable granting her a bond or in this VOP for her to go and deliver herself to road to recovery, she's asserted to me she has a person that can effectuate that. But I don't know the answer from road to recovery or the state's
And I'm not
position.
trying to vary the terms of the contract with the state. I just didn't know physically, and using the word collect sounds like you're an object, which you're not. I don't know if physically they send somebody or if you've got to have somebody that takes you directly there. Yes, ma'am.
And Your Honor, I don't believe road to recovery would pick them up. I would just request that within 24 hours of release, she report to road to recovery and confirm with probation that she's there.
Okay, 24 hours from release. So she's going to be released today? Okay. And so continues on her probation till the bed becomes available, and then she has to report within 24 hours of when the bed's available. Is that what I hear?
Okay.
Okay. Thank you, Ms. Eisen.
Thank you. Thank you, State.
Next is Silvers, Michelle Silvers. Ma'am?
Ryan Morrow from Ms. Silvers, Your Honor, is two matters before the court, 20 CF 1718 and 20 CF 2285. Both matters are VOP. The defense is in the process of having Ms. Silvers evaluated for the Keaton program. The state has mentioned drug court, though it's not yet clear whether or not she's going to be qualified, so I'm going to have that evaluation done as well as covering all my bases, Your Honor. So with that, I'd ask the court to consider allowing me to continue these matters to the 4/10 date.
Okay. Ms. Silvers, so that means that I'll see you back here no later than April 10th. If you want to enter a plea before that time, then Mr. Morrow can get you before the court, and I'll see you then, okay? Thank you, Your Honor.
Next is Rogers. Joshua.
Joshua Rogers. Please step out.
Hello, Mr. Rogers.
How you doing?
You're doing well, thank you. I'm just trying to, good. Mr. McKinney's coming up.
This is Mr. Rogers,
22 CF 2260.
So she's here for a bond hearing today.
Okay, that wasn't on the docket, so I haven't done my homework.
Joshua Rogers, he should be on the docket.
No, he's on the docket, but it doesn't show bond here.
Oh, interesting.
Oh, Joshua Rogers, right?
Eddie Rogers and Joshua Rogers.
Yep,
This is
got it.
Joshua
27, I have done my homework. Mr. Rogers, it says that you've been in jail since July 21st of last year.
Yes, sir.
Present bail is $25,000. You're employed with Texas Roadhouse for 7 months. Lived in the area your entire life. Single and have 2 children, 15 and 8. And that you have a high school graduation or graduate level of education.
I've actually got a 2-year college degree too, sir.
Good. I was wondering what the NCCER is. What is that?
That's the National Center for Construction Education and Research. It's a trade college through the Florida Department of Education. I've got an HVAC.
In what?
HVAC.
HVAC.
Yes, sir.
Good. Thank you, sir.
Judge, if we go into, if we rely primarily upon the motion here, and since the court has been explained what the abbreviations are, Mr. Rogers cannot make the $25,000 cash professional bond. Anything that the court feels appropriate, given the nature of this case related to pretrial services, no contact, GPS monitoring, anything that the court feels is appropriate to reduce the dollar amount. The dollar amount is what's causing Mr. Rogers to be stuck in jail. He would certainly be compliant in having no contact with the victim. He has no desire to contact the victim, and would comply with anything that the court so chose, including GPS monitoring if it was necessary. So we're before the court asking for a lesser amount other than the $25,000 cash professional that is currently set.
Okay, thank you. To the state, I did read the addendum to probable cause and highlighted some of that. What does the state wish for me to know?
Judge, at this time, Ms. Toops would like to address the court regarding the bond situation.
Okay, good. Ms. Toops?
Please remain standing and please work with us. You swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Stoops, if you'll make sure you speak into the microphone, okay? To the state.
Ma'am, can you state your name for the record?
Erica J. Toops.
Okay, and how do you know this defendant?
East of 8.
How long did you know him?
Obviously not very well.
How long?
How long? We met in May of 2021.
And ma'am, you wanted to address the court regarding this bond motion.
Yes, ma'am.
Okay, what would you like Judge Brown to know before he makes a decision on whether or not to lower Mr. Rogers' bond?
I would like to request that the lower bond be denied to allow me to confer with Santa Rosa County to extend my order of protection. It will elapse the 23rd of this month.
How has this event affected you?
In every way. I'm a single mother of 4 children. I haven't worked in almost a year because he ran me over with my own car. My children have suffered. My emotional state has suffered, and everything around me.
And my understanding is you had some extensive medical bills as a result as well.
Extensive, yes. I had reconstruction surgery on my ankle a year ago yesterday. There are also other people in Santa Rosa County that need to be protected. His child is one of them.
I don't have any other questions.
Any questions from Ms. Toops?
Ma'am, you believe that what happened to your ankle and your foot was an intentional action by Mr. Rogers?
Absolutely.
Is it your primary goal to have no contact with Mr. Rogers?
Absolutely.
I have no further questions.
Ms. Toops, so You're asking for the bond, at least what you stated, asking for the bond not to be reduced. And then you mentioned that there's a no contact order that's in place in Santa Rosa County that expires soon.
In less than a week.
Okay. So if this court
Releases him.
If I modify the bond and say no contact with you and require him to wear a GPS monitor, why wouldn't that allay your fears?
Because he has a history of breaking and entering, harassment, and stalking. And he lives less than 25 minutes from my home.
Okay.
And I have 4 children to protect.
Yes, ma'am. I'm just trying to figure out why you
His
said-
mother lives less than 15 minutes from my home.
Okay. And it would say that he couldn't go within 500 feet of your home, have no contact with you.
When he was released in July, he already made attempts to frequent the establishment that I go to on a weekly basis.
He was released in July.
In Virginia court, he was released. He immediately came back to Escambia County and was requesting to go back to the establishment that I frequent on a weekly basis.
So July of last year?
Yes. Even with an order of protection in place, he wanted to come back to Santa Rosa County.
So
He attempts to do so.
Okay, tell me about that.
He contacted many people on my pool league, asking to come back to play where I play on a weekly basis. I was just there last evening with my children for birthday.
And those attempts were done after?
The order of protection is in place.
Okay, after March 11th of last year.
Yes, sir.
Any other questions from either of the attorneys based on the court's questions?
No, Your Honor.
No, Judge.
Okay. Thank you, Ms. Dukes. You can step down.
Thank you, Your Honor.
Mr. McKinney, it's your motion?
Yes, Your Honor. The address listed in the bond motion is actually in Pensacola, so I believe that that's not where you just heard that Mr. Rogers would be staying from Ms. Toops. He has no desire to contact Ms. Toops. If the court wanted to make it a provision of don't play pool, he would not play pool. If the court is concerned about him being in a pool league, he has no desire to have any contact with her at all. The court can be guaranteed through the GPS that he not have any contact with her and have know where his whereabouts are at all times with GPS monitor. It's the $25,000 amount that is the problem for Mr. Rogers. I believe that the court can apply pretrial services and anything else on as far as conditions that the court would feel appropriate to make sure he has no contact with Ms. Toops. That would suffice.
To the state?
Judge, I can't say anything more as far as factually than what I believe Ms. Toops has already stated. What I can add at this point is Mr. Rogers has an extensive criminal history dating back many years, including DUIs, multiple leaving the scenes of accidents, grand theft auto, grand theft of a firearm. So Mr. Rogers is not new to the court system. Obviously, what gives the state the biggest pause is what Ms. Toops was explaining about Mr. Rogers going to places that Ms. Toops frequents. So trying to subvert what the court had already ordered by not necessarily going to where she lives, but someplace that she frequents. So it definitely gives the state a large concern if Mr. Rogers' bond was lowered. We would ask that obviously if Your Honor does make the decision to go forward with lowering the bond, that Mr. Rogers forfeits any weapons in his possession. He shouldn't. He's a convicted felon, so he shouldn't have, especially any firearms. That he be required to wear a GPS monitor, that all the pretrial services, bells and whistles that can be in place to protect Ms. Toops and her family, that they be imposed, Your Honor.
Were those conditions of the $25,000 bond? Well, let me just make it easier. Mr. Rogers, what I learned after being on the bench is that when it comes for a modification of a bond, I can modify the bond either up or down. The motion for bond reduction is denied, so the amount will remain the same, but if I'm modifying the bond, if it's not, doesn't already say pretrial services, no contact with the alleged victim, not go within 500 feet of the alleged victim, the alleged victim's residence, vehicle, or any place that she frequents. If you're released, you also need to wear a GPS monitor and surrender any weapons to these. If you're in Santa Rosa County Clerk's Sheriff's Office, I'm sorry. If you're in Okloosa County, to the Okloosa County Sheriff's Office. So when will I see Mr. Rogers next?
Judge, the case has been continued so that we can complete depositions in the matter. So Your Honor would see Mr. Rogers again on May 8th.
Okay. Mr. Rogers, I'll see you on May 8th in the morning. Thank you.
Next is John Smedley.
Thank you. Well, Mr. Smedley.
Judge, this is Mr. John Smedley before the court. Mr. Smedley is here in a total of 5 cases before Your Honor. The court's previously reviewed a report and I believe found Mr. Smedley to be incompetent to proceed and found that he does not meet criteria for Florida State Hospital and that competency restoration is to be done at the Okloosa County Jail. Since we have come from that court date, I've been in communication with Mr. Barnes, who's going to be the individual who is going to be doing the competency restoration with Mr. Smedley at the jail. Mr. Barnes is present in the courtroom if the court has any questions. I think as far as paperwork goes, my review of where we need to go from here, since it's not the classic conditional release plan, since he's technically not being released, we'd still need to fit in the terms and conditions in a conditional release plan, even if he is to remain at the Okloosa County Jail for the competency restoration. So I believe that I can continue to work with Mr. Barnes on getting that paperwork for the court. And I know that Mr. Barnes is putting together a treatment plan for Mr. Smedley. If the court has any questions about that, Mr. Barnes is present in the courtroom.
Okay. I do not. I mean, Mr. Barnes is very competent in that area. So I think that he'll be diligent on that, Mr. Smedley. So they'll come up with a treatment plan. How far out we want to set another step.
Next available judge to make sure that we get all the paperwork cleared, which I know is the April 10th date, but I can submit the conditional or release plan or treatment plan to the court and the appropriate orders ahead of time if all parties agree. And as we had with Mr. Rowell earlier, in a conditional release plan, even if Mr. Smedley is going to be staying at the Okloosa County Jail for competency restoration, he would have to be aware of the terms and conditions of that plan and sign off on that, even the state that we're currently in.
Understand. Why don't we set it for April 13th, because I think the 10th may be slammed.
Yes, sir, April 13th, but I believe that that's primarily going to be status. I think we can get a lot done prior to that to go ahead and get Mr. Smedley on a plan.
So, Mr. Smedley, I'll see you back here no later than April 13th at 9 o'clock. Mr. McKinney will be talking to you a lot about what's going on between now and then, okay, what the plan is. Okay, thank you, sir.
Next is Malcolm Hawkins. Hawkins?
Ryan Morrow for Mr. Hawkins, Your Honor. This is 15 CF 443 Alpha. I've spoke to the state on this. Mr. Hawkins has provided me with some documentation that may indicate completion of some of the conditions, if not a good faith effort towards some of them. but I don't have complete information. I was going to ask if the court would be willing to put this on 410. I would ask for 323, but it's my understanding Ms. Barrettman will be in Crestview that day.
Okay. Yes, ma'am.
Judge, there's no objection to continuance.
Okay. So it'd be April 10th at 2:30, is that what you're saying?
The morning would be fine, Your Honor.
Okay, 9 o'clock on April 10th.
Thank you, Your Honor.
So what's going to happen between now and then?
I'm going to engage in a little additional discovery on my end, Your Honor, and then I'm going to present that to the state and probation once I have all my information.
Okay. The lady who was standing in.
I thought you guys were done.
Ma'am?
I thought you guys were done.
Oh, okay.
She's here for Mr. Hawkins.
Okay, good. Mr. Hawkins, I'll see you back here on April 10th at 9 o'clock, okay? Thank you, sir.
This is Matthew Townsley.
Ryan Morrow from Mr. Townley, Your Honor. This is 22 CF 1085 Alpha. The case is VOP. This is going to be a negotiated plea for an admission. The agreement between the parties contemplates the reinstatement of probation, added condition of completion of Haven House inpatient program. Again, this will be bars to beds, and I have heard, or at least through Mr. Townley's family, that they will need about a week to come in and retrieve him, Your Honor. $100 VOP fee, $150 cost of defense. We impose all original terms and conditions. He was previously adjudicated, Your Honor. And if I can have a moment to get a signature, I'll approach with the offer, Your Honor. And I will ask that the court consider waiving his cost of supervision while he's in that program. This is not like Heaton. His family's having to come out of pocket to send him to this particular program, Your Honor, so we're asking the court to consider that.
Thank you.
May I approach?
Yes, sir. Please. Thank you. Thank you, sir.
Hold on, please.
Mr. Talley, if you'll raise your right hand, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. You can put your hand down. Talley, the folks in the back, are they here for you?
Yes, sir.
Good. Just to disclose that I know, who's the lady that's sitting back there in relation to you?
It was my mother.
Good. That I know Mr. Talley's mother from where she works at Neighborhood Cafe, and so I see her frequently, talk to her about taking over her grandchildren and those things. We haven't talked about Mr. Talley's case with any particularity. She may mention something in passing, but as far as substance, don't do that. But I want to disclose that.
Yes, sir.
For what it's worth, the defense has no problem with any of that, Your Honor.
Mr. Talley, so did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Talley, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated, but it is modified so that you'll need to enter and successfully complete the Haven House inpatient treatment program. It's a $100 cost of prosecution, $150 public defender's fee, will be bars to bed, so you'll go straight from the jail to Haven House, and we'll talk about that in a moment. I do waive the cost of supervision while you're in Haven House. The original terms and conditions are reimposed. As far as getting Mr. Talley, you mentioned about a week.
And his mother had corresponded with Haven House. I have not spoke with him directly, but it's my understanding they'll be here sometime next week.
So a bed will be available next week, and his mom will... Yes, ma'am. Why don't you approach? Come on up. We'll just come up to the bar.
And I believe that the bed is there, Your Honor, it's just they come.
Okay. Yes, ma'am.
The bed is available. They just don't have anyone that can come and take the 4 hours to get him from jail to probation and then back to the jail and then to the Miramar, where the program is. So it will be Monday next week before they can retrieve him.
Okay.
So
Before they can, so they're going to pick him up.
yes,
correct?
they will pick him up. He won't have anything for the first 2 months. It's a very strict program. And Matthew has expressed that he's ready for this. So, I mean, I'm giving him his last chance.
So let me ask you this, not to put you on the spot.
Yes.
But if I said that you could take him directly to Haven House, is that something you want to do? Or do you want them to pick him up directly?
Me and his father could do it.
So, I mean, do it sooner than later, you can do it.
I can contact the director today, and he can. I can ask him if we can bring him, and it will be solely up to them because their program is strict.
Right.
So I will contact them when we leave here. Or I can actually call him now outside the courtroom and let you know.
Okay, just, I'll put in the order, Madam Clerk will put on the minutes that Mr. Talley can be released either to you, to the mother, or directly to Haven House as soon as you are informed that there's a bed that's available.
Okay, so if I pick him up, he can remain with me or until we can get him there maybe on Monday, or he goes from the jail to the Haven House.
Directly from the jail
let me-
to
let me
Haven House.
Call them and I will let you know. I'll
Okay.
call him right now.
Okay.
Judge, I know as part of that circuit, he's gonna have to stop at probation.
Okay, good. To the mom, you'll have to stop at probation? Okay, good, thank you.
We appreciate the court's time and consideration, Your Honor.
Absolutely. Mr. Talley, I was speaking about somebody else, and I thought, I analogize what may be your past, as far as drugs and those things, with the royal family and Harry. And I think, and I don't know if you followed that at all, but, you know, I think about Harry leaving and the world that he saw when he got out from behind the gray suits. And the same thing with you. If you can get this monkey off your back, you're going to see a whole new world that I think is excellent. So I really wish you the best.
Yes, sir. I think I'm on my mom already. I overdosed in January and really got me because my cousin died last year.
Wow.
So.
Gosh. Yes, sir. Thank you. Thank you, sir. Good luck to you.
Thank you. Thank you, sir.
Do we need anything else on this, Your Honor?
No, sir, I don't think so.
Okay, thank you, Your Honor.
Next is Hickok. Last name.
Judge, this is Robert Hickok before the court in 19 CF 2438 and 19 CF 2439. In this case, Mr. Hickok, to bring the court up to speed, was originally before Judge Stone in Division 2 and entered a plea up to Judge Stone, which was a plea straight up to Judge Stone. Mr. Hickok was out on bond at that time, and prior to or shortly after the sentencing, he never made it to the sentencing, and there was a failure to appear. He was taken into custody in another state. He served a prison sentence, and he was returned to us. So it's an older case. I bring the court up to speed because the discussions I've had with Mr. Hickok since he's been back with us here, since he entered the plea directly to Judge Stone, I asked, do you want to be sentenced by Judge Stone? And we've been trying to get a sentencing date with Judge Stone since approximately December. In my last reach out to his office, I don't believe that he indicated that he wished to do that, so I scheduled the status for today. I wanted to bring the court up to speed and make sure the court knew the background of where Mr. Hickok's coming from. It's a status today. If the court is inclined to sentence Mr. Hickok, I'd like a sentencing date so that we can prepare. Because I know Mr. Hickok has family that would be appearing via Zoom, and there's going to be some logistics involved. So I set it for today just to see if the court wanted to talk to Judge Stone, or if we just wanted to set the sentencing hearing with yourself. I believe Mr. Hickok at this point just wants the sentencing to happen.
Okay. First, let me figure out the legal part of it. So let me ask you a question. Did you say that Mr. Hickok pled in front of Judge Stone straight up?
Correct. With no agreement with the state.
Okay. Mr. Hickok, the reason why I asked that question is, then you have, I believe, that you have the right to be sentenced by that judge. Just because we've rotated divisions, and I may be wrong, but I would think that you would still have that right. If a judge dies or something, you don't have that right because they aren't available. I know that there are other things. If a judge retires, they're unavailable. I would think just by rotating, that wouldn't be the effect. So if you say I have the right to be sentenced by Judge Stone and I want to be sentenced by him, then I would suggest that we put you on the next date that I've got, and I talk to Judge Stone up front and say, if he wants to be sentenced by you, can you make accommodations to do that? When can we do it, and try to schedule it up? If he says, John, here's the law that says once I rotate out, it's not mine, and you do it, then I'll schedule up the sentencing with Mr. McKinney and I'll sentence you. Subject to Mr. McKinney saying, nope, you still got that, that right.
May I have just a moment?
Sure.
Judges, and I've spoken with Mr. Hickok about this. His desire at this point, if we were to ask him back in November, was I was sentenced by Judge Stone, let me be sentenced by Judge Stone. I believe he's in a position now, given the passage of time, that he wishes to waive being sentenced by Judge Stone to be sentenced by Your Honor, and we just ask for the next available date. I know that he wants to be sentenced as quickly as possible so that we can be in a position to just make our argument.
Okay. Mr. Hickok, do you agree with that? You waive your right to be sentenced by Judge Stone?
Yes, Your Honor.
Okay. Mr. McKinney, so you want to, Madam Clerk, how hooked up are we on the afternoon at 1:30 on April 10th?
All you have said is 3 years.
Great. You want to do that?
Yes, Judge, if that's the next available, I would like the next available. I don't anticipate that it's going to be a very long sentencing.
Okay. April 10th at 1:30. So, Mr. Hickok, I'll see you in a few weeks, okay? I'll do my homework, whatever I'm given, and I'll see you then.
One second.
Send it to me, so I'll put it in my room. Okay.
You guys.
Next is Mark Riley.
This is Mr. Mark Riley Jr. before the court in 22 CF 209. Do you have a chance to read this over?
Yeah, right. I'm trying to see if they can do reinstate. They don't want to do reinstate?
That was not what they wanted to do.
Can you ask them to see if they will?
I asked them before. Your options are, do we set this for a hearing, or do we take this 6 months, what they come down to?
Okay, as long as they take the misdemeanor with them.
Not misdemeanor, the
Not the misdemeanor charge them or obstruct.
Okay. Well,
And then I'll take, if they take that, and go with that.
Judge, Mr. Riley's question is he has a pending misdemeanor, which is a resisting without violence. That's not Ms. Davis's case, but he's asking if the state would look at that to see if they would include that to go ahead and resolve that case as well. With the 6 months county jail. I know that's pitching it at Ms. Davis because that's not her case.
Do we want to pass Mr. Riley's case and bring him back this afternoon?
Yeah, we're gonna have to, because I need to reach out to the prosecutor on that case and see what the story is with it.
Can we bring him back at 1:30?
2:30, we've got arraignments at 1:30, so
2:30.
2:30.
Yes,
So Riley,
sir.
I'll see you at 2:30.
Thank you.
They won't transport you back, okay? So Allison, you'll make sure of that? Thank you.
Thank you.
Yes, ma'am.
So I talked to Mr. Palmer, and I Matthew said to be released at 8 a.m. tomorrow morning.
Okay.
We will pick him up, take him from there to probation here, have him transferred. We will take him from there to Defuniac probation, and then from there to the Haven House. He has given us until 1 o'clock tomorrow to have him in his presence. Can his attorney ask him what size pants he wears? Because I need to buy him clothes. When they picked him up, he didn't have nothing but his boxer shorts on and a tank top. Could you let me know? So,
I will let you know.
he's gained a few pounds.
Okay, so we can just make sure that the mother can pick him up tomorrow.
8 a.m. So we'll be there.
Okay, that'd be good.
Has he been brought down already?
Yes.
And then she'll take him to probation and then to.
What size pants he wears?
That'd be great.
No, I'm sorry. No. Next is Eddie Rogers.
Yeah.
It's Frank McKinney downstairs yet. No, can you ask him what size pants he wears? Thank you. I'm sorry.
So that was just broadcast throughout the courthouse.
Okay, it was.
That's not related to you. It's not related to you. They're not concerned about your pants size.
That's right. Mr. Rogers, how are you?
Judge, Mr. Rogers is here in 22 CF 2260 for a felony violation of probation. We've spoken at the jail. For Mr. Rogers' benefit, the state's offer right now, if you were to accept it, would be 11 months and 29 days in the Okloosa County Jail, but it would be credit from the time of your arrest in the VOP. You would not get all the credit from before. From before, you would not get it.
The credit from when?
The time of his violation of probation arrest.
Which, do you know when that was?
September 1st.
September 1st?
Yeah, 31st. I got booked the 1st September. Yeah.
I think it's
I got booked September 1st, and I got put in the county jail. Yeah, I can't do the probation. I my heart. Yeah, yeah, I do. I'm 9 times, sir.
Credit. May I have just a moment, Judge?
Yes, sir.
Mr. McKinney, to be clear, that would be credit only from the VOP arrest?
Correct.
Okay.
And that's what I'm making sure that we are all on the same page about, because Mr. Rogers has indicated he's inclined to take that agreement, but I want to make sure he understands how much credit that he is realistically talking about here.
Yes.
But I show that the date of the VOP arrest is July 30th of this year.
Mm-hmm.
So you would have credit.
You mean of last year?
No, of this year.
Oh, we haven't hit July yet.
I said July and I meant January.
Okay.
In January 30th of 2023 is when the BOP was served. So you would get credit from January 2023 on the 1129 sentence to revoke or terminate your probation. Is that something that you're comfortable with? You want to talk to me more about?
What's that off? I mean, there's none there.
That is the offer.
He's still prison. He's still in prison. I was good at 1129.
Yeah. You good with that?
Yeah.
Judge, I don't have a written plea agreement based on the way that this has turned out.
Yes, sir.
For Mr. Rogers. But in 22 CF 2260, Mr. Rogers would wish to admit the violation of probation and be sentenced to 11 months and 29 days in the Okloosa County Jail. That would be a negotiated downward departure sentence. That would revoke and terminate his probation. If I didn't so already announce, he'd be adjudicated guilty, and he would get credit from the VOP arrest, which I show as January 30th, 2023.
Okay. There'd be a $100 cost of prosecution, $150 public defender's fee.
Correct.
Okay. Mr. Rogers, if you'll raise your right hand, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Thank you, sir. You can put your hand down. So, Mr. Rogers, here's what I hear. One is that you would be waiving your right to basically a judge trial for the court to decide whether you violated your probation. Do you understand that?
Yes, Your Honor.
And you'd be sentenced to 11 months, 29 days in the Okloosa County Jail with credit from January 30th of 2023. This year.
Yeah.
Right?
Correct.
Yeah.
Okay. Do you still wish to enter the plea?
Yes, Your Honor.
Mr. Rogers, I do accept your plea. You're adjudicated guilty. Your prior supervision is revoked and terminated. You're sentenced to 11 months, 29 days in the Okloosa County Jail with credit for time served from January 30th of 2023. It's a $100 cost of prosecution, $150 public defender's fee. This is a negotiated plea for a downward departure. Mr. Rogers, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate
Yes, Your Honor.
rights? Mr. Rogers, do you want the outstanding financials to immediately go to a civil lien or judgment, or do you want a period of time to pay those after you get out?
Period of time.
Okay.
You know,
9 months?
Yes, Your Honor.
Okay. So if you fail to pay the financials within 9 months after your release, then they'll go to a civil lien or judgment. Thank you, sir.
Thank you, Your Honor.
Don't go anywhere just yet. You've got this, Mr. Miller. Okay, states whether your time served, John. I would suggest that you do that so that you're totally clear. Judge, he also, Madam Clerk, he has 23 MM 172, which is a misdemeanor case that I've discussed with the state, that the state would agree to a time served agreement with misdemeanor court costs if this court were willing to accept it.
Okay.
And we would stipulate to this court's jurisdiction to hear that misdemeanor.
Mr. Rogers, you agree to that?
Yes, Your Honor.
Then the court accepts that plea.
That is a one-count information that charges loitering and prowling by a sex offender in close proximity to children. That is a first-degree misdemeanor, and it would be a time-served agreement with misdemeanor court cost and an additional misdemeanor $50 cost of defense.
Those amounts are imposed and time served. Thank you, sir.
Next is Christopher Brown.
Your Honor, before we go on to Mr. Brown, Mrs. Townley has raised an issue. It's my understanding she has a schedule conflict tomorrow morning, and she asked me to inquire if the court would be willing to amend the order to include both parents, so such that as
I
follows.
take the kids to school at 7:40. He's in night school, closer to Crestview, so he can, in fact, we can be released to him. His father's Glenn Townley. And he will bring him to football and we'll do everything from there.
Okay. So Glenn Townley will pick him up tomorrow morning at 8.
Yes.
Good. Thank you, Mr. Townley.
Thank you, Your Honor.
Mr. Brown.
Yes, ma'am.
Ryan Morrow for Mr. Brown, Your Honor. This is 21 CF 2130. This is going to be a negotiated plea to the violation of probation. I'll announce the sentence.
Yes, sir.
It's agreement of the parties anticipates that the court will reinstate and modify the probation to run concurrent on both counts. Modify the probation such that the next 6 months will be community control, and then the remainder of the balance of probation will be the drug offender program or drug offender probation, with the added condition of intensive outpatient treatment and aftercare at Lakeview, $100 VOP fee, and $150 cost of defense. I'll pause and give my client a moment to sign.
And it's outpatient.
Yes, Your Honor. Intensive outpatient treatment with aftercare. May I approach?
Yes, sir. Thank you. Mr. Brown, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Brown, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
And
Did you sign the plea agreement?
I did.
Thanks. Mr. Brown, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated and modified so that the next 6 months of your supervision will be community control. Then the balance of your supervision will be drug offender probation. You will be in the intensive outpatient aftercare at Lakeview.
Yes, sir.
Okay.
Thank you, Your Honor.
Thank you, sir. There's a $100 cost of prosecution, $150 public defender's fee. Court does waive the cost of supervision. Well, you're in the outpatient, so I don't waive that. But good luck to you, Mr. Brown. Good seeing you again, sir.
Thank you, Your Honor.
Martinez Gonzalez. Martinez Gonzalez.
Ryan Morrow for Mr. Martinez Gonzalez, Your Honor. This is 18 CF 2955 and 22 CF 2219. Both cases are VOP. The defense is going to ask for a continuance in this matter to 410. Probation has recommended Keaton in this matter. I'm waiting for a word back.
Okay. Mr. Martinez Gonzalez, do you agree to the continuance?
Yes, sir.
Okay, you understand what's going on with your case?
Yes, sir.
Good, then I'll see you back here on April 10th. Thank you, sir.
Thank you.
Next is Joseph Mazone.
Zone, Your Honor. This is 22 CF 26.
How you doing, sir?
Good, how are you?
This is 22 CF 2655, Your Honor. The agreement of the parties contemplates that this is going to be an admission on the VOP for the negotiated plea agreement, Your Honor. The agreement contemplates we ask the court to revoke and terminate the probation, sentence Mr. Mazzone to time served, $100 VOP fee, $150 cost of defense, all financials reduced to a lien after 6 months. I'll pause, give my client an opportunity to sign.
Judge, I'll provide a score sheet to the court after.
There you see one on this one.
You're correct.
Yeah, Brooke, Your Honor.
Yes, sir. Mr. Mazzone, if you'll raise your right hand. Good. There you go.
Yeah, the right.
Yes, sir. The right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down. Mr. Mazzone, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Mazzone, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. Your current supervision is revoked and terminated. You'll need to pay the $150 public defender's fee, $100 cost of prosecution. Those amounts, as well as all other outstanding financial amounts, will go to a civil lien or judgment 6 months from today if you fail to pay those, okay?
Okay. I pay him here at the courthouse.
Yes, sir, correct. And you can talk to the clerk about a payment plan if
Okay.
you want.
Very good. Very good.
Keep up your sense of humor, okay?
Yes, sir.
Thank you, sir.
Thank you. Hello, coming out.
Knopfsinger.
Ryan Morrow from Mr. Mr. Knopflinger, Your Honor. This is 22 CF 2754 Alpha. We had passed this matter from a February date to allow him an opportunity to observe mental health treatment court. Unfortunately, I was advised yesterday afternoon that he is not going to be a candidate based on his status. So at this point, I would ask the court to allow me to move this case to 410 to see if we had come up with an alternative resolution, avoid drawn out sentencing hearing or evidentiary hearing, Your Honor.
Do you know what the offer is from the state?
I haven't heard since.
It's gonna be a guidelines offer, Your Honor, I'm pretty sure, but I need some time because we just found out. We thought it might be different.
Me and Mr. Gomez were hopeful about NHC, but we were informed by Ms. Sharpless, unfortunately, due to his status as a violent felony offender of special concern, he won't be eligible for the program. Additionally, he doesn't have a place to stay right now, and that's going to cause a lot of issues.
Okay. Mr. Knopflinger, I'll see you back here on April 10th at 9 o'clock.
Quentin Purnell.
Hello, Mr. Purnell.
How are you doing, sir?
Good, how are you?
Doing well,
Good.
Ryan Morrow for Mr. Purnell, Your Honor. This is 22 CF 519 Alpha. The case is VOP. This is going to be an admission with a negotiated plea. The agreement of the parties contemplates that will ask the court to reinstate and modify the probation such that the next 6 months will be community control, $100 VOP fee, and $150 cost of defense. I'll pause and give my client an opportunity to sign.
And what is the adjudication?
I believe he was previously adjudicated, Your Honor, but
Mr. Purnell, were you previously adjudicated as a felon? Guilty?
I believe so.
Okay, thank you. Mr. Purnell, you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand up. Mr. Purnell, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Purnell, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated with all the original terms and conditions. However, it's modified so that the next 6 months of your supervision are community controlled. You'll need to pay the $100 cost of prosecution, $150 public defender's fee.
Yes, sir.
Thank you, sir. Good luck to you.
Thank you.
Thank you, sir.
Your Honor, Chris Robinson is an inmate, but his private attorney is not here. You want us to have him back at 1:30?
That would be great. Who's his attorney?
I have no one.
This is Larissa. Ms. Dudley. Okay, so I need to try to get a hold of Ms. Dudley.
And Your Honor, I have 3 matters that I need to address.
Okay, yes, sir.
On the docket this morning was a Dustin Golden, 2 matters, 20 CF 82 and 20 CF 81. Appeared in my queue yesterday for filing was a notice of appearance. I only file notice of appearance in felony VOP matters that don't involve any law violations. So when it appeared in my queue, I assume that's what this was. I was doing my homework, preparing for court this morning, Your Honor, and when I look at the clerk's site on Mr. Golden's matter, the clerk's site doesn't indicate a VOP. It says something like case reopened for any other reason, and I see a motion, a pro se motion to preserve evidence. I've had a short. Go ahead, Your Honor. I'm sorry.
I did see that motion. Yes.
So at this point, and I've spoke with some of my colleagues here, I think I'd probably make a motion to withdraw and ask the court to relieve me. I don't believe that we should be on this case.
I think the order was already entered denying that motion.
The motion to be relieved or the motion for reserving evidence?
The motion
for
to reserve evidence.
I've
You
seen
know-
it filed a few times also.
Yeah.
It
Do you
seems
know
that
the case number?
I've got
There's 2 cases, Judge.
20 CF 82 and 20 CF 81. And I was anticipating, based on what I saw on the docket, that he was going to appear via Zoom from DOC. I wasn't really sure what to expect, but that's what I know, Your Honor.
Okay. And so that's on the docket for today?
It was.
Interesting. Okay, let me check into those, okay? I know that I've had different communications with the staff attorneys. I don't know, and I did see that motion, but I don't know what the resolution is. So let me,
What I'm trying to ascertain is, does the public defender still need to be on the case? Because what my file reflects is that he was sentenced to 36 months DOC. This isn't an appellate case or anything like that.
right. I would think that your representation would stop once he was sentenced.
Right. I just I don't know why my file management thought to reopen this file and assign it to me. So I'm trying to ascertain if the court thinks I still need to be
Let
on
me
this
see,
case.
the easiest answer would be if the court's already ruled on those motions.
Right.
Then they're gone.
Okay.
So I'll check on that.
Okay, thank you, Your Honor. That's thing one. Thing two is Joshua Carter, 41 CF 803. He's on the docket. I don't believe he was transported. I think he was a late addition.
Okay. Allison, as far as,
We don't have Joshua Carter here.
okay.
I'm not sure if he's an inmate.
Okay.
Do we know if he's an inmate?
I don't know the answer to that, Your Honor. This file appeared in my office this morning.
I also have an active warrant. Yeah.
Okay.
Probably not.
Probably not in there, right?
May not be. I just had a red sticker on my file, so I asked them to bring them out. I didn't have any information other than that.
So on Mr. Carter's case, what does the state wish to do?
Requesting KPS, Your Honor.
KPS will be issued for Mr. Carter, and the first appearance judge will determine the bond.
I think that's all I have, Your Honor. Does
Okay.
the court have anything else for me?
No, sir.
All right, may I be excused till the afternoon?
Yes, sir.
Thank
See you
you.
then. Thank you. Mr. McKinney?
Judge, I had Jasmine Williams on the docket in 3 case numbers. She was unable to be transported due to her behavior. And pending before the court, what I was going to ask the court to do, on March 3rd, I filed a motion seeking a first expert for competency evaluation. There would just need to be an order for that. If the court doesn't have it in its queue, I do have a physical copy of an
Yes, sir.
order.
That'd be great.
May I approach?
Please.
And so the court's fully up to speed. This was an in-house evaluation by Dr. Zeman. She refused that evaluation. That's referenced in the motion. And Dr. Zeman indicated to me that she cannot refuse if the court appoints him in this
Good.
fashion.
Okay. Thank you. So do we want to continue Ms. Williams' case?
Yes, Your Honor, we have the next available date.
As a status.
Okay. April 10th at 9 o'clock.
Thank you, Judge.
Madam Clerk, anything else we need to do for the 9 o'clock? Thanks, y'all. We're in recess until 1:30.
Judge,
All right.
it's nothing that needs to go on the record.